The Supreme Court on Monday appeared divided on both merits and legality of proposed Purdue Pharma bankruptcy plan, which would allocate billions of dollars to help alleviate nation's opioid crisis while shielding family that owns company from future lawsuits. ArrowRight Justices across ideological spectrum asked tough questions of Justice Department attorneys opposing the deal, Purdue attorneys and multiple parties interested in outcome. These parties say unraveling the resolution plan would leave some victims with nothing. Forget a better deal. There is no other deal, said Pratik Shah, a Washington attorney who represents the interests of states, hospitals, tribes, insurance companies, individual victims and other creditors who accepted the settlement. However, Curtis E. Gannon, representing the Department of Justice, said that this claim has already been proven false, after some states and individuals objected an earlier version of the plan. The Sackler family, which owns Purdue, raised more cash and increased its contributions from $4 billion to nearly $6 billion. Be paid out over nearly 2 decades. He said. Gannon said another deal could also be made that does not require eviction or bankruptcy. We hope there will be another agreement at the end of this, he said. Purdue declared bankruptcy in 2019 as it faced thousands of lawsuits and allegations that company fueled the opioid crisis by marketing blockbuster pain OxyContin. However, members of the Sackler family did not file for bankruptcy. The legal issue before court is whether, under federal bankruptcy laws, the Sacklers can be protected from future opioid-related lawsuits for their alleged role in fueling nation's crushing opioid crisis. The board found that such an arrangement was permitted under 2 provisions of the law. One says bankruptcy court may issue any order, action, or decision necessary or proper to carry out the provisions of law. The other says a plan may include other appropriate provisions not inconsistent with applicable provisions of the law. The appellate court interpreted this to mean that the bankruptcy court can approve provisions that are not expressly prohibited by statute. On Monday, Judge Brett M. Kavanaugh seemed to agree. He said 30 years of bankruptcy practice gives courts wide leeway in determining the best outcome in such complex restructuring cases. Kavanaugh appeared criticize federal government's decision to halt plan over theoretical idea that there might be ways get more money from Sacklers, which he said had no part in it. Justice Elena Kagan also emphasized pragmatic aspects of agreement and noted that overwhelming majority of victims who voted for plan approved agreement. Kagan said she had reason to think Sacklers were the worst people in the world but still supported deal. But others, including Justices Neil M. Gorsuch and Ketanji Brown Jackson, noted that other regional appellate courts have disallowed schemes that terminate W.